Welcome to video 29 in our AI-powered research series. Today we're covering something many researchers overlook until it's too late: intellectual property considerations when using AI tools. This is the three-point IP audit you should conduct before uploading any content to an AI system. Here's why this matters. When you use cloud-based AI tools, you're entering into an agreement with the AI provider. That agreement typically includes terms about what happens to the content you upload. Some providers claim rights to use your inputs for training. Some claim broad licenses to your content. Some have terms that might conflict with your publishing agreements or institutional policies. Most researchers click accept without reading these terms. That's understandable. Terms of service are long and written in legalese, but ignorance doesn't protect you from the consequences. Before you upload unpublished research, proprietary data, or content under contract, you need to understand what rights you might be granting. The three-point audit gives you a systematic way to assess this. By the end of this video, you'll know exactly what to check and how to protect your intellectual property. Let's understand what's at stake with AI and intellectual property. When you paste text into ChatGPT or upload a document to Claude, you're sharing that content with a third party. The AI provider's terms of service govern what they can do with that content. Some terms to be aware of: many providers retain the right to use inputs for model improvement. This means your content could become part of the training data for future AI versions. Even when providers say they don't train on your data, there are often exceptions or ambiguities. The content you share might not remain confidential. Terms often allow providers to review content for safety, legal compliance, or quality assurance. Human contractors might read your conversations. Output ownership is also complex. Who owns text generated by AI? The answer varies by provider and by how you use the tool. In some cases, you may have limited rights to commercialize AI-generated content. These terms can conflict with other agreements you've signed. Your publishing contract might prohibit sharing your manuscript with third parties. Your institutional policy might restrict how you handle certain data. Your grant might require specific intellectual property protections. The three-point audit helps you identify these conflicts before they become problems. Here's the three-point IP audit to conduct before using any AI tool with your research content. Point 1. Check ownership clauses. What does the AI provider's terms of service say about content you upload? Look for language about licenses, rights granted, permitted uses, and ownership. Does the provider claim any rights to your inputs or to outputs generated from them? Point 2. Check training rights and opt-out options. Does the provider use inputs to train their models? Is there an opt-out mechanism? For many tools, enterprise or paid tiers offer different terms than free versions. Make sure you understand which terms apply to you. Point 3. Check output licensing. What rights do you have to the AI's outputs? Can you use them commercially? Can you publish them? Are there attribution requirements? Are there restrictions based on how the content will be used? After conducting this audit, compare what you learned against your other obligations. Do any of these AI terms conflict with your publishing agreements, institutional policies, grant requirements, or data use agreements? If there's any conflict, don't upload that content until you've resolved the issue. Let me walk you through the specific terms to look for in AI provider agreements. Under ownership clauses, look for phrases like "you grant us a license," "we may use your content," or "you retain ownership." The key question is whether you're giving the provider rights beyond what's necessary to process your request. Under training rights, look for language about improving our services, developing new features, or training AI models. Then look for opt-out provisions. Some providers allow you to exclude your data from training through settings or by using specific API configurations. Under output licensing, look for who owns the generated content, what you can do with it, and whether there are restrictions. Some terms grant you ownership of outputs, others grant you a license with conditions. Red flags to watch for: perpetual, irrevocable, worldwide licenses, rights to sublicense your content, absence of clear opt-out mechanisms, vague language about how content may be used. Remember that terms change. The agreement you accepted 6 months ago might not reflect current terms. Re-audit periodically, especially when providers announce policy updates. Here are practical steps to protect your intellectual property when using AI. Step 1. Use enterprise or professional tiers when available. These often have better IP terms, including commitments not to train on your data. The cost is usually worth it for serious research use. Step 2. Enable opt-out settings where available. Some providers let you opt out of having your conversations used for training. Find these settings and activate them. Step 3. Consider when to use local AI instead. For highly sensitive or proprietary content, running AI models locally ensures your data never leaves your machine. The capability trade-off may be worth the protection. Step 4. Be strategic about what you upload. Grammar checking on your methods section? Probably fine. Your unpublished results or the novel theoretical framework that's your dissertation's core contribution? Be more careful. Step 5. Document your audit. Keep records of what terms you reviewed, when you reviewed them, and your assessment. This demonstrates due diligence if questions arise later. Step 6. Consult your institution when in doubt. Technology transfer offices and research compliance staff can help you navigate complex IP questions. Here's the impact of conducting IP audits before AI use. When you understand the intellectual property implications of AI tools, you can use them confidently while protecting your interests. You avoid inadvertent IP loss. By knowing what rights you're granting, you ensure you're not giving away more than you intend. Your unpublished work remains under your control. You maintain compliance with other agreements. When you know AI terms might conflict with publishing contracts or institutional policies, you can avoid that conflict. No unpleasant surprises when you're trying to publish. You make informed trade-offs. Sometimes the convenience of an AI tool is worth accepting certain terms. Other times it's not. The audit gives you the information to decide. You can advise others. When colleagues or students ask about AI and IP, you can share what you've learned. This multiplies the benefit of your knowledge, and you contribute to market pressure for better terms. When researchers understand and push back on problematic terms, providers have incentive to offer better options. Let's summarize the key takeaways from this video. First, AI providers' terms of service affect your intellectual property. When you use cloud AI, you're sharing content under specific terms that may include rights to use, license, or train on your content. Second, conduct a three-point audit before uploading sensitive content. Check ownership clauses, check training rights and opt-out options, check output licensing, then compare against your other obligations. Third, know the red flags, broad perpetual licenses, rights to sub-license, no opt-out mechanisms, vague usage language. These should give you pause. Fourth, protect yourself proactively. Use enterprise tiers when available, enable opt-outs, consider local AI for sensitive content. Be strategic about what you upload, document your audits, consult institutional resources when needed. Make the IP audit a standard step before using AI with important research content. This video is part of a series based on the book Impact or Invisible: Surviving the Data Age with AI by Angel Reyes, available on Amazon. Here's your takeaway to remember. Every time you upload content to an AI tool, you're entering into an agreement. Know what that agreement says before you click submit. 3 points: ownership clauses, training rights, output licensing. Check all three, compare against your other obligations, and proceed only when you're comfortable. The researchers who protect their intellectual property will have more options when it comes time to publish, patent, or commercialize their work. In our final video in the Ethics and Responsible AI Use series, we'll cover the trust but verify protocol for AI outputs. If you found this valuable, subscribe and hit the notification bell so you don't miss it.